Hello, everyone. Today's case is Trump v. Barbara. So this is the citizenship question that was brought up about birthright citizenship. So let's see what the Supreme Court said. The question presented is whether the Constitution guarantees citizenship to children born in the United States of parents who are unlawfully or temporarily present in the country. Under the Citizenship Clause of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. On January 20th, 2025, President Trump issued Executive Order number 14160, titled Protecting the Meaning and Value of American Citizenship. The order provides that children born in the United States of parents who are unlawfully or temporarily present here are not subject to the jurisdiction of the United States, and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, INA, which uses the same language. Several parents filed suit, some in the name of their children, arguing that the executive order violates the 14th Amendment and the INA. The district court agreed, provisionally certified a nationwide class of children who would be denied citizenship by the order, and preliminarily enjoined the order's enforcement. This court granted certiorari before judgment. Held. Children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. The Citizenship Clause must be understood in light of its historical context, from the English common law to the widespread condemnation of the court's decision in Dred Scott v. Sanford. Under the English common law, children born within the sovereign's dominions owed a natural allegiance to the sovereign who protected them at birth, regardless of how momentary and uncertain their presence. Such children were therefore natural born subjects. The same rule applied to children born of parents subject to expulsion. The rule's exceptions were narrow. Children born in lands the sovereign did not control, children born in areas temporarily outside the sovereign's control, and children of foreign ministers, by a fiction of extraterritoriality. This common law of citizenship, known as jus soli, or right of the soil, crossed the Atlantic and prevailed in each and all of the states after American independence. The rule was applied even to the novel situation of quasi sovereign Indian tribes, who maintained dominions of their own, such that Indians born under those dominions were not citizens but members of alien and sovereign tribes. In a nation of immigrants, jus soli's broad scope took a particular importance, assuring that children of foreigners, including those here on a temporary sojourn, would be American citizens by birth alone. In Dred Scott v. Sanford, the court departed from the common law and adopted the view that blood, not soil, determines citizenship. It held that those descended from slaves could not be citizens. The decision was met with shock, and abolitionists swore to undo what the court had done. In the midst of the Civil War, Attorney General Edward Bates issued a landmark opinion citing key authorities, including Calvin's case and Kent's commentaries, rejecting the premise that citizenship is ever hereditary, and declaring that every person born in the country is, at the moment of birth, prima facie a citizen, without any reference to race or color. The exceptions were few. The small and admitted class of natural born, composed of the children of foreign ministers and the like. Following the war, Congress sought to turn Bates' opinion into law by enacting the Civil Rights Act of 1866, which made citizens of all persons born in the United States and not subject to any foreign power, excluding Indians not taxed. The act was simply assumed to invoke the common law rule. What the Civil Rights Act began, the 14th Amendment and its repudiation of Dred Scott would finish. The 14th Amendment's Citizenship Clause mirrored the common law's criteria for citizenship, starting with territory, a child must be born in the United States and ending with sovereign power. A child must be subject to the jurisdiction of the United States. A child born on American soil and subject to American law was made an American citizen. Even the language of the clause is that of the common law, echoing cases and treaties that described the common law rule. And its principal author explained that its language was simply declaratory of the law of the land already. The Citizenship Clause's key phrase, subject to the jurisdiction, refers to the power of the United States to govern those within its territory. The scope of that power was settled largely by schooner exchange of the McFadden. where Chief Justice Marshall explained that jurisdiction referred to the full and complete power of a nation within its own territories, susceptible of no limitation not imposed by the nation itself. The narrow exceptions to jurisdiction arose where exercising jurisdiction would degrade the dignity of foreign sovereigns, most frequently in the case of foreign ministers. But private individuals who traveled to the United States for business or caprice were amenable to the jurisdiction of the country. Amenable to the jurisdiction of the country. Children born in the United States to parents unlawfully or temporarily present here are thus subject to the nation's jurisdiction. The court's precedent in United States v. Wong Kim Ark confirms this rule. For nearly 2 decades after the amendment's ratification, the executive branch viewed the Citizenship Clause as simply an affirmance of the common law, with the limited exception of the children of foreign ministers and others with rights of extraterritoriality. But the end of the Reconstruction era brought uncertainty. Around that time, the State Department began to deny citizenship to those with dual or doubtful allegiance, and several scholars proposed a new international law-based theory of the Citizenship Clause, focused on the parent's status, not the child's. Only if a child's parents were domiciled in the United States was the child internationally subject to the jurisdiction of the United States, as the Citizenship Clause, they said, required. Acknowledging that the common law took a different view, these writers insisted that jus soli had not been made part of the Constitution. In Wong Kim Ark, the court held that the 14th Amendment was declaratory of the fundamental rule of citizenship by birth that prevailed at common law, excluding only those recognized as exempt from the jurisdiction of this country, the children of ambassadors, and those born in the nations of Indian tribes. All others were citizens at birth, whether born to permanent residents or temporary visitors. The court wrote that the words subject to the jurisdiction thereof must be presumed to have been understood in the same sense, as Chief Justice Marshall used them in Schooner Exchange. Under that understanding, aliens who traveled to the United States for business or pleasure received no exemption from the jurisdiction of the country. To the contrary, they were subject to that jurisdiction for as long as they remained here, and any children born to them were American citizens under the 14th Amendment. Arguments for limiting birthright citizenship to those domiciled in the United States fail. These arguments err in their definition of allegiance, contending that natural allegiance was no longer sufficient for citizenship and that some greater quantum of allegiance based on domicile was required. There is scant evidence for this dramatically revisionist view. Sources from 1776 to 1868 defined allegiance by birth just as the British did, as the tie or duty owed by one who is born within the dominions and under the protection of a particular sovereign. Domicile and national citizenship are distinct concepts. One who establishes a domicile in a new country does not automatically become a citizen thereof, nor does he automatically lose his prior citizenship. The congressional debates over the Civil Rights Act of 1866 and the 14th Amendment confirm the common law rule. Statements embracing the common law rule were far more frequent and explicit than ambiguous references to temporary sojourners. For a Congress intent on putting the question of citizenship once and forever to rest, a domicile-based qualification would have introduced significant uncertainty. Yet the word domicile appears just twice in the discussion of the relevant provision of the Civil Rights Act, and in only one speech from the Citizenship Clause debates. Sources from after the ratification of the 14th Amendment do not put in doubt the understanding of the Citizenship Clause at the time of and after its ratification. In any case, post-enactment history cannot override the text. If Congress intended to limit American citizenship to the children of those domiciled in the United States, nothing in the succinct language of the Citizenship Clause conveyed that design. Words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. Attempts to narrow Wong Kim Ark by noting that the court's opinion repeatedly referred to the domicile of Wong's parents fail because the holding's underlying reasoning cannot be squared with a domicile requirement. The court exhaustively canvassed the text and history of the Citizenship Clause and at no point identified any evidence that the ratifiers thought themselves to be imposing a domicile limitation. Affirmed. Chief Justice Roberts delivered the opinion of the court, in which Sotomayor, Kagan, Barrett, and Jackson joined. Jackson filed a concurring opinion, in which Sotomayor joined as to the introduction and Part 1. Kavanaugh filed an opinion concurring in the judgment and dissenting in part. Thomas filed a dissenting opinion, in which Gorsuch joined. Alito and Gorsuch filed dissenting opinions. Chief Justice Roberts delivered the opinion of the court. At issue in this case is whether the Constitution guarantees citizenship to children born of parents unlawfully or temporarily present in the United States. The 14th Amendment provides, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. On January 20th, 2025, President Trump issued Executive Order Number 14160, titled Protecting the Meaning and Value of American Citizenship. The order provides that children born of persons unlawfully or temporarily present in the United States are not subject to the jurisdiction of the United States, and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, INA, which uses the same language. Several parents filed suit, some on their own behalf, others on behalf of and in the name of their children. They argued that the executive order violates the 14th Amendment and the INA. The district court agreed. It provisionally certified a nationwide class of children who would be denied citizenship by the order and preliminarily enjoined the order's enforcement. We granted certiorari before judgment. To understand the citizenship clause of the 14th Amendment, it is first necessary to understand the context in which it arose, and the opinion of this court, Dred Scott v. Sanford, that it rejected. The story of citizenship in the United States begins with the English common law. Before the Revolution, the American colonists, like all in the British Empire, were considered subjects of the sovereign. That arose not from royal fiat, but from what the common law conceived as the relationship between the sovereign and the people. The king, Blackstone explained, owes those born within the dominions a duty of protection. And in return for that protection, those born within the dominions owe the king a duty of allegiance, sometimes rendered allegiance. Children born with that allegiance were natural born subjects. As Lord Coke put it in the celebrated Calvin's case, a dual and reciprocal tie thus connects the sovereign and his subjects. Because the sovereign's power, and thus his duty, was limited in various respects, so too was the scope of this rule. He could not demand allegiance from, for he could not protect those born in lands that he did not control. Among that group were the people born in the king's lost dominions, France, Aquitaine, Normandy, over which he claimed an absolute right but had no actual power to rule. The same held true even in discrete areas within his kingdom that were temporarily outside his control. If enemies were to possess a castle or fort, their children would not be born under the king's legions. And the same held true for ambassadors and their families, who were considered by a fiction of extraterritoriality to remain on foreign soil and thus under the legions of their home country. In all other respects, however, the sovereign's power and his claim to the people's allegiance was complete. A foreign mother could enter the British Isles, give birth, and leave with her child the very next day, and that child would remain a British subject. Why? Because the child owed an implied allegiance to the sovereign who protected him at his birth, no matter how momentary and uncertain his presence in the king's realms. The same rule applied to children born in the realms of parents subject to expulsion. For example, children of gypsies, today called Romani or Roma people, born in the realm were natural born subjects, notwithstanding the British law at the time directed the Roma people to avoid the realm under pain of imprisonment or even death. See brief of Magliocco as amicus. Describing outcry in 1855 when Massachusetts deported a pauper Irish mother with her American-born infant who was acknowledged to be a native-born citizen. For those children and all others born in Britain, the rule was the same. With protection came allegiance, and with allegiance came the status of a natural-born subject. This view crossed the Atlantic with the colonists, and was adopted with little fanfare after the Revolution, as subjects of the sovereign became citizens of the states. This common law of citizenship, known as jus soli, or right of the soil, prevailed in each and all of the states after American independence, and continued to emphasize reciprocal allegiance and protection. See Kent, Commentaries on American Law. By the doctrine of natural allegiance, all who were born within the jurisdiction of a state were citizens. When the newly independent Americans confronted a novel situation unknown to England, That of the quasi sovereign Indian tribes, they turned to the principles of the common law. Did the tribe truly govern their people, or were their people wholly subsumed within the United States? Echoing Coke and Blackstone, Chancellor Kent answered with the common law. We have purchased the greater part of their lands, destroyed their hunting grounds, and gradually abridged their native independence, Kent acknowledged. Even so, he reasoned, the United States has never dealt with those people within our national limits as if they were extinguished sovereignties. They were instead dependent nations that maintained dominions of their own. Indians born under those dominions, he concluded, were not citizens or subjects of the United States, but members of alien and sovereign tribes. Others followed Kent's lead, all the while emphasizing that the very few exceptions to the sovereign's power were narrow indeed. In a nation of immigrants, an asylum for mankind, in Thomas Paine's words, Just Solis' broad scope took on particular importance. The young republic attracted tens of thousands of emigres from the Old World, Scotch-Irish, French, German, Welsh, and many more, some of whom hoped to stay only a short time, others of whom hoped never to leave. No matter their intentions, however, they could be assured that their children would be American citizens by birth alone. As Justice Story said, nothing is better settled. The very first American legal treatise agreed. See Swift, A System of the Laws of the State of Connecticut. Children of aliens are citizens, for they owe a duty at birth to the government under whose protection they came into existence. As did the antebellum era's foremost case on the topic, Lynch v. Clark. Lynch reiterated that the common law rule was the law of the land, for the children of citizens and foreigners alike, including those foreigners here merely on a temporary sojourn. The promise of American citizenship, Lynch declared, extends to all persons born within the jurisdiction of the United States. The common law made no distinction on account of race or color, but the slave states did. As the Civil War approached, more and more southern states sought to deny citizenship to black Americans, and openly rejected the common law to reach that result. It was not the place of a man's birth that made him a citizen, these states said, but the rights and privileges he may be entitled to enjoy. On that view, the prejudice of caste was unconquerable. Not even emancipation could confer citizenship. These states held because free African Americans still suffered from social and civil degradation based on the taint of blood. With the common law abandoned, almost 500,000 free black Americans in the South were left little more than strangers. In the odious decision of Dred Scott v. Sanford, this court imposed the Southern states' beliefs onto the nation. Chief Justice Taney, writing for the court, concluded that the words people of the United States and citizens had an unexpressed and atextual racial component, one that excluded all those descended from slaves. Even if Massachusetts or Connecticut chose to grant citizenship to the freedmen, they still could not participate in national affairs. They were born in the country, Chief Justice Taney acknowledged, and thus did owe allegiance to the government, the precise criteria for citizenship at common law. But they were not included and were not intended to be included under the word citizens in the Constitution. For them, blood, not soil, was made the rule. Dred Scott was met with shock. Ever since the Declaration of Independence, Justice Curtis wrote, the received general doctrine has been, in conformity with the common law, that all free persons born within a state are citizens of the United States. Justice McLean said much the same. Being born under our Constitution and laws, he explained, makes him a citizen. Northern newspapers condemned Dred Scott as a wicked and false judgment, an atrocious doctrine, a deliberate iniquity, and a willful perversion. The decision was, in Lincoln's famous words, an astonisher in legal history. Abolitionists swore to undo what the court had done. By birth, Frederick Douglass insisted, we are American citizens. The Constitution knows all the human inhabitants of this country as the people, he explained, no matter their color, class, or clime. All I ask of the American people is that they live up to the Constitution, adopt its principles, imbibe its spirit, and enforce its provisions. When this is done, Douglass predicted, the glorious birthright of our common humanity will once again become the inheritance of all the inhabitants of this highly favored country. The court had overruled the common law, but the people eventually would overrule the court. It took more than a decade, and the addition of names such as Antietam, Gettysburg, and Chancellorsville to our national canon. But Douglas's vision of our common humanity would be fulfilled. The Reconstruction Congress did not start from scratch. In the midst of the Civil War, President Lincoln's Attorney General Edward Bates had issued a landmark opinion that sought to displace Dred Scott in favor of the common law. Citing the key authorities, among them Calvin's case and Kent's commentaries, Bates rejected the premise that citizenship is ever hereditary. Every person born in the country, he wrote, is at the moment of birth prima facie a citizen, without any reference to race or color or any other accidental circumstances. He acknowledged that there were some limits, hence prima facie, not conclusive. But those exceptions were few, simply the small and admitted class of the natural born composed of the children of foreign ministers and the like. To Bates, it was soil, not blood, that furnishes the rule both of duty and of right. A year after General Lee's surrender at Appomattox, Congress sought to turn Bates' opinion into law. The result was the Civil Rights Act of 1866. The act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby citizens of the United States. To the Reconstruction Congress, the act was simply assumed to invoke the common law rule. As Bates had in his ablest and most exhaustive opinion, and as the New York Court of Chancery had in the great case of Lynch v. Clark. Indeed, the bill's sponsor, Senator Lyman Trumbull, enthusiastically agreed with the bill's critics that it would make citizens of the children of Chinese and Gypsies born in this country. Even the infant child of a foreigner born in this land is a citizen. Under this bill, Trumbull declared. The specter of Dred Scott, however, loomed over Congress's efforts. Opponents of the act contended that Congress could not grant such expansive citizenship and set aside this court's precedent by statute alone. To quiet those concerns and to permanently enshrine the common law in the Constitution, Congress turned to the 14th Amendment. What the Civil Rights Act began, the 14th Amendment would finish. Like the act, the 14th Amendment was intended to repudiate Dred Scott. This time, however, the goal was even grander, to put the great question of citizenship beyond the legislative power altogether, to settle the issue once and for all. The 14th Amendment achieved its aim. The Citizenship Clause mirrored the common law's criteria for citizenship. The clause starts, like the common law, with territory. A child must be born in the United States, not elsewhere, even to American parents. And the clause ends, again like the common law, with sovereign power. A child must be subject to the jurisdiction of the United States, unlike, say, the families of foreign ministers. A child born on American soil and subject to American law was made an American citizen. Even the language of the clause is that of the common law. Lynch held that American citizenship extended to all persons born within the jurisdiction of the United States. So did Chancellor Kent. Kent, all persons born within the jurisdiction and allegiance of the United States are citizens. So did the first legal treatise on the rights of free black Americans. C. Yates, all who are born within the jurisdiction of a state are citizens. And so did the famed antebellum lawyer Horace Binney. C. Binney, children born within the limits and under the jurisdiction of the United States are citizens. Little wonder, then, that the Citizenship Clause's principal author would explain that its language was simply declaratory of the law of the land already. The law was clear. Any child who was born under the protection of the United States, that is, any child for whom no extraterritorial fiction applied, was made a citizen, for he owed a natural allegiance and thus obedience to the nation. See Senator Morrill. The essential elements of citizenship are allegiance on the one side and protection on the other. Even putting the common law to one side, the Citizenship Clause's key phrase, subject to the jurisdiction, requires the same result. The word jurisdiction was hardly unknown to the drafters and ratifiers of the 14th Amendment. Congress chose to use an established legal term, and the clause must be interpreted in that light. In 1868, as today, jurisdiction, in the context of a sovereign, refers to the power of governing or legislating. See Dictionary of Terms and Phrases used in American or English jurisprudence from 1879. The authority of government, the sway of a sovereign power. To be subject to the jurisdiction of the United States, then, is to live under its dominion. a meaning reinforced by the clause's territorial focus on those born in the United States. The Citizenship Clause uses jurisdiction in its ordinary sense, referring to the power of the United States to govern those within its territory. The scope of that power was well settled in 1868, largely by the celebrated case of Schooner Exchange v. McFadden. Expounding on general principles, Chief Justice Marshall explained that jurisdiction referred to the full and complete power of a nation within its own territories. That absolute power was susceptible of no limitation not imposed by the nation itself. All sovereigns, however, were understood to have impliedly waived their jurisdiction in certain peculiar circumstances, in essence, where exercising jurisdiction would degrade the dignity of foreign sovereigns. And in the context of jus soli, those peculiar circumstances arose most frequently in the case of foreign ministers. Every sovereign would hazard his own dignity, after all, if his officials abroad were made to owe temporary and local allegiance to a foreign prince. The limits of that exception were carefully defined. Still within the United States power were the private individuals of a foreign nation who had spread themselves through our territory as business or caprice may direct. It would be obviously inconvenient and dangerous to society, and would subject the laws to continual infraction, Chief Justice Marshall explained, if such individuals or merchants were not amendable to the jurisdiction of the country. Nor can the foreign sovereign have any motive for wishing such exemption, he continued, with respect to its sojourning subjects who were not employed by the sovereign or engaged in national pursuits. Just like jus soli, the sovereign's jurisdiction had made no exception for those only temporarily present within the sovereign's territory. Instead, nearly everyone within the territorial boundaries of the United States was amenable to the nation's jurisdiction. The ordinary legal meaning of the text of the clause thus neatly captures the common law rule, with its broad reach and narrow exceptions. The same groups included and excluded by jus soli were included and excluded by the conventional understanding of jurisdiction. Excluded by both were the children of foreign ministers and members of 19th century Indian tribes over whom the United States had ceded a part of its territorial jurisdiction to preserve its relationship with a foreign sovereign, or quasi-sovereign. No such inter-sovereign concerns apply to children born of parents unlawfully or temporarily present in the United States. No foreign sovereign would have any motive for wishing them outside this nation's authority. Those children are thus subject to the jurisdiction of the United States. They satisfy both elements of the Citizenship Clause. They are born in the United States and subject to the jurisdiction thereof. Under the Constitution, they are citizens at birth. Our precedent, the seminal case of United States v. Wong Kim Ark, confirms this rule. For nearly 2 decades after the 14th Amendment's ratification, the executive branch viewed the Citizenship Clause as simply an affirmance of the common law of England and of this country. Under that view, the status of citizenship was fixed by the place of nativity, irrespective of parentage, with the limited exception of the children of foreign ministers and of other persons who may be within our territory with rights of extraterritoriality. And of other persons who may be within our territory with rights of extraterritoriality. In 1872, for instance, Attorney General George Williams was called upon to determine the citizenship of a child born of Austrian parents only by temporarily residing in New York City. Citing the Citizenship Clause and Bates' 1862 opinion, Williams explained that a person born in this country, though of alien parents who have never been naturalized, is, under our law, deemed a citizen of the United States by reason of the place of his birth. Thus, the child is a native of this country, Williams concluded, and as such was originally clothed with American nationality. Secretary of State Hamilton Fish agreed. So did federal courts. Like the executive branch, they saw the clause as merely declaratory of the rule of the common law. As the era of Reconstruction faded, however, so too did the promise of birthright citizenship. Uncertainty came with the first Chinese Exclusion Act of 1882, and the election of President Cleveland, the first Democrat to hold the office since the Civil War. It was around this time that the State Department began to deny citizenship to those with dual or doubtful allegiance, and it was around this time that several scholars proposed a new theory of the clause, one based on international law. This new theory focused on the parent's status, not the child's. It was only if a child's parents were domiciled in the United States, they argued, that the child was internationally subject to the jurisdiction of the United States as the Citizenship Clause, they said, required. These writers acknowledged that the common law took a different view, and acknowledged that the language of the 14th Amendment is very broad. But they insisted that jus soli had been universally rejected by other nations and had not been made part of the Constitution. In Wong Kim Ark, this court rejected that view, concluding that no rule of international law had qualified the ancient rule of citizenship by birth within the Dominion. At issue was the citizenship of Wong Kim Ark, born in San Francisco to Chinese parents. In Wong's telling, the case was not close. There can be no just doubt, he argued, that the amendment was intended to be based upon the doctrine derived from the common law that the character of a natural-born citizen is incidental to birth only. The government disagreed. It admitted that the opinions of the attorneys general, the decisions of the federal and state courts, and up to 1885, the rulings of the State Department all concurred in the view that birth in the United States conferred citizenship, based on the common law doctrine of allegiance and the authority of the decision of Chancellor Sanford in Lynch v. Clark. But the executive no longer endorsed that view. The common law doctrine of England, it argued, had in fact never been the doctrine of the United States, and was not made the law by virtue of the Citizenship Clause. In an opinion by Justice Gray, the court rejected the government's position. Justice Gray explained that the 14th Amendment was merely declaratory of the fundamental rule of citizenship by birth. That prevailed at common law. That same rule, he wrote, was in force in all the English colonies and continued to prevail under the Constitution, and its contours were clear. It excluded those recognized as exempt from the jurisdiction of this country, the children of ambassadors and other representatives of foreign sovereigns, as well as those born in the alien nations of Indian tribes. All others were citizens at birth, whether born to permanent residents or temporary visitors. Indeed, Justice Gray noted, no one had even contested this conclusion for more than 50 years after the adoption of the Constitution, until the matter was elaborately argued before the New York Court of Chancery in Lynch v. Clark. And there the question was decided upon full consideration by Vice Chancellor Sanford in favor of their citizenship. The same doctrine was repeatedly affirmed in the executive departments, Justice Gray wrote, not to mention by Kent and Binney, each of whom affirmed that the child of an alien, if born in the country, is as much a citizen as the natural-born child of a citizen. In adopting the common law, Justice Gray explained, the Citizenship Clause adopted this same rule. Justice Gray then turned to Schooner Exchange to confirm what the common law made clear. The words, subject to the jurisdiction thereof, he wrote, must be presumed to have been understood and intended by the Congress in the same sense in which the like words had been used by Chief Justice Marshall in the well-known case of the Exchange. On that understanding, aliens who traveled to the United States for business or pleasure received no exemption from the jurisdiction of the country. To the contrary, they were subject to that jurisdiction for as long as they remained here, and any children born to them were American citizens under the 14th Amendment. What the court held in Wong Kim Ark was simple. The Citizenship Clause incorporated the common law and granted citizenship to nearly all children born in the United States. Not surprisingly, then, in the 128 years since, we have repeatedly understood the rule of Wong Kim Ark to guarantee citizenship to all children born in the United States and subject to its power. We see no reason to depart from that view today. The government and the principal dissent share many of our premises. They agree that the Citizenship Clause was intended to incorporate the background principles of the common law. They agreed that under the common law, citizenship turns on allegiance. And they agree that Dred Scott departed from that traditional allegiance-based view of citizenship, a departure that Congress repudiated in the clause. Where the government and the principal dissent err is with their definition of allegiance. They concede that Calvin's case and Blackstone state the rule that prevailed before the Declaration of Independence, that a natural allegiance arises for all children who are born here under the protection of the sovereign. Yet, according to the government and the principal dissent, the United States' conception of allegiance, at some unspecified point in time, broke from Great Britain's. See the brief for petitioners. The government has variously dated this change to the late 18th century, the early 19th century, and the Reconstruction era. The principal dissent declines to offer a date. Natural allegiance, they contend, was no longer sufficient for citizenship. Some greater quantum of allegiance was required. How much? The government offers a smorgasbord of formulations. primary allegiance, sufficient allegiance, full allegiance, requisite allegiance. See the brief of petitioners. The principal dissent, for its part, seems to have settled on primary allegiance. What all these formulations supposedly share is that they turn on domicile, the place of one's permanent home. At some point before the ratification of the 14th Amendment, the argument goes, it became deeply rooted in this country that domicile is the key concept that creates allegiance. The trouble is that there is scant evidence for this dramatically revisionist view. Certainly, no one said that such a change had occurred. Indeed, even as the antebellum Americans hotly debated whether the Declaration of Independence had abrogated one aspect of the British common law, that natural allegiance was indefeasible no matter a person's desire to expatriate. All agreed that such allegiance was owed in the first place. Perpetual allegiance does not stand up to the same reason or principle as the common law doctrine of allegiance by birth. See Murray v. Schooner, Charming Betsy, noting unsettled question of whether an American citizen can divest himself absolutely of his citizenship, but simply presuming that any person born within the United States was a natural-born citizen. The only evidence the government and the principal dissent can muster to show that some alternative primary conception of allegiance displaced the common law is a funeral oration for President Lincoln. Ahistorical modifiers aside, the government and the dissent identify no source that defined allegiance at birth as being based on domicile in the period from 1776 to 1868. Sources from that period instead defined allegiance by birth just as the British did, as the tie or duty owed by one who is born within the dominions and under the protection of a particular sovereign. See an American Dictionary of the English Language in 1828. Every native owes a natural or implied allegiance to the government under which he is born. Of course, some wish to change that rule. But even those who wished to limit jus soli did not deny that children born of temporary visitors owed natural allegiance to the United States. They instead thought that domicile might serve as a reasonable qualification to the common law rule, namely, that citizenship derives solely from the natural allegiance owed to the government of the territory of a man's birth. The principal dissent, but not the government, at times seems to directly equate domicile and national citizenship. That is wrong. It is, in fact, a general axiom of international law that there may be domicile where there is no nationality and nationality where there is no domicile. After all, one who establishes a domicile in a new country does not automatically become a citizen thereof. He has to be naturalized, nor does he automatically lose his prior citizenship. He has to expatriate. Thus, the principal dissent ultimately acknowledges that domicile alone was insufficient to make someone formally a citizen. Of course, domicile was relevant to naturalization and expatriation, but that by no means suggests it was a prerequisite to national citizenship at birth. The principal dissent's reliance on cases concerning changes to a person's state citizenship is thus misplaced, and the government's remaining support for the idea that a domicile qualification to birthright citizenship was widely accepted in the United States before the Civil War. Consists of a single state court case. The brief of petitioners consists of a single state court case about citizenship in the Republic of Texas, a proposed but never adopted model code for the state of New York, and another treatise that discussed the subject only in terms of the principles of natural reason, which it expressly distinguished from the common law. The congressional debates over the Civil Rights Act of 1866 and the 14th Amendment confirm our view. The principal dissent and the government lean heavily on a handful of ambiguous floor statements referencing temporary sojourners and foreigners. See Representative Wilson from the 39th Congress. It may be that children born on our soil to temporary sojourners do not fall within the Act's scope. And also Senator Howard. The citizenship clause would not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers. Far more frequent and explicit, however, were statements embracing the common law. And the debates make clear that no member of Congress seriously grappled with a domicile-based carve-out to the fixed, certain, and intelligible rule of the common law. For a Congress intent on putting the question of citizenship once and forever to rest, a domicile based qualification would have introduced significant uncertainty. Unlike the easy to apply common law, it would be difficult, if not impossible, to lay down any general rule of domicile based citizenship, as domicile often depends upon the circumstances of each case, the combinations of which are infinite. If Congress intended to hinge citizenship on each individual's domicile, a question that is sometimes a matter of great difficulty to decide, it is reasonable to expect there would have been at least some discussion of the topic. Yet the word domicile appears just twice in the discussion of the relevant provision of the Civil Rights Act, and it appears in only one speech from the Citizenship Clause debates, as part of an explanation of why state citizenship is distinct from national citizenship under the Constitution. Perhaps recognizing the absence of ratification era support for a domicile based rule of national citizenship, the government and principal dissent both emphasize sources from after the ratification of the 14th Amendment. They turn to the same international law treatises that underpinned the government's attempts to limit birthright citizenship in the 1880s. This fundamentally revisionist scholarship and the post 1884 executive branch actions that relied upon it do not put in doubt the understanding of the Citizenship Clause at the time of and after its ratification. As Senator Trumbull explained in 1871, the Citizenship Clause recognized that every person born within the jurisdiction of the nation was a citizen of the United States and had been true under the common law of this country as well as of England. In any case, post-enactment history cannot override the text. If Congress intended to limit American citizenship to the children of those domiciled in the United States, nothing in the succinct language of the Citizenship Clause conveyed that design. Words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. For a simple reason, they did not matter. And while the clause does not ensure state citizenship attaches to U.S. citizens in the state wherein they reside, the explicit invocation of residence for state citizenship only highlights its absence from the criteria for U.S. citizenship. See the slaughterhouse cases. A person can be a citizen of the United States without being a citizen of a state. When the principal dissent does grapple with the operative legal text subject to the jurisdiction of the United States, it has little to say. It argues only that a person is subject to the jurisdiction of the government of his domicile, but that is not the question. The question is whether a person is subject to the jurisdiction of the government of the country in which he is physically present, even if he is only there temporarily. He is, unless he falls under one of the familiar exceptions, such as for ambassadors. For the reasons given by Chief Justice Marshall in Schooner Exchange, the United States exercises full and complete power, its absolute and complete jurisdiction over temporary visitors. To avoid these problems, the principal dissent spends much of its time on the text of the Civil Rights Act. Justice Alito does the same, albeit in service of a different result. The Civil Rights Act made citizens of all persons born in the United States and not subject to any foreign power. The principal dissent contends that a person is not subject to any foreign power if and only if he is domiciled in the United States, for it is then and only then that his home nation is forbidden from regulating his conduct. Justice Alito contends that a person is not subject to any foreign power if and only if no other country would automatically make him a national, whether he is domiciled here or not. Neither theory works. As to the principal dissent, it is simply not true that domicile in a new nation severs one's ties to the old one. See story. Nations generally assert a claim to regulate the rights, duties, obligations, and acts of their own citizens wherever they may be domiciled. If the test truly is whether a person is amenable to the laws of two governments at once, then it is a test that every child born to a foreign parent fails, a result that even the principal dissent cannot stomach. Justice Alito seems to recognize this bind, so he would create an ad hoc exception for those whose parents have done everything within their power to become Americans. He does not explain how that exception can be squared with his view of the text, which, to repeat, is that anyone automatically made a national of his parents' native country was not entitled to citizenship under the Civil Rights Act. In our estimation, the Act raises more questions than answers and was replaced by the 14th Amendment, which better expresses the views of the Reconstruction Congress anyway. This court said as much in Wong Kim Ark. Any possible doubt about the meaning of the Civil Rights Act was removed by the change to the affirmative words of the Citizenship Clause. For the dissents and the government, Wong Kim Ark is essentially irrelevant. They attempt to narrow that precedent by noting that the court's opinion repeatedly referred to the domicile of Wong's parents. That is true, but the reasoning underlying the holding of Wong Kim Ark cannot be squared with a domicile requirement of the sort the government envisions. As we have already explained, the court exhaustively canvassed the text and history of the Citizenship Clause. It traced an unbroken line from the English common law into the founding and antebellum eras, and through the debates to the clause's ratification. Yet at no point did the court identify any evidence in the historical record that the ratifiers of the 14th Amendment thought themselves to be imposing a domicile limitation. In the end, it is the dissent in Wong Kim Ark that makes the strongest case for, for a domicile based theory of American citizenship. There, Chief Justice Fuller resisted the application of the English common law rule because it recognized no exception in the instance of birth during the mere temporary or accidental sojourn of the parents. He admitted that, in England, the question of domicile is entirely distinct from that of allegiance, because the one relates to the civil and the other to the political status. One relates to the civil and the other to the political status. But he believed that a different view as to the effect of permanent abode on nationality had been expressed in this country. Under this different view, the 14th Amendment prevented the acquisition of citizenship by the children of aliens whose parents owed local and temporary allegiance, merely remaining subject to a foreign power. The government and today's dissenters agree, but this view commanded only a dissent in 1898, and neither time nor circumstance has changed the fact that it is not the law. Again and again, the dissents cast the common law as feudal, medieval, a remnant of the darkness of the Middle Ages. That was not the view of the Reconstruction Congress. Where the dissents see feudalism, the framers of the 14th Amendment saw emancipation. By the time of the Glorious Revolution in 1688, in fact, the tie created by birth was less a duty than a right, the foundation of the ancient liberties of free-born subjects. That is why Blackstone described the privileges owed to the natural born. That is why the colonists demanded the rights of Englishmen more than 250 years ago. And that is why abolitionists lauded the ancient and universal rule of citizenship by birth alone as an ordinance of heaven. Citizenship then and now was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended that promise to every freeborn person in this land. We keep that promise today. The judgment of the District Court for the District of New Hampshire is affirmed. It is so ordered. Justice Jackson, with whom Justice Sotomayor joins as to the introduction and Part 1 concurring. I join the court's opinion in full. I write separately to respond to some of the themes in the principal dissent. Despite his long-standing endorsement of a colorblind constitution, Justice Thomas now surprisingly suggests that the Citizenship Clause was a race-conscious remedial measure relating only to freed slaves such as Dred Scott, and those who shared with them certain characteristics. See his opinion, No Other Homeland, and then Called America Home. It is for this reason, he says, that children who were born in the United States but to parents not domiciled here are not entitled to claim birthright citizenship. But that narrow vision of the 14th Amendment bears little relationship to the history of its ratification. Even worse, Justice Thomas telling elides the entire point of the second founding. The Reconstruction Amendments were an anti-caste, anti-subordination reset for the nation, not a mere spot treatment for the dark stain of slavery. It is common ground that the 14th Amendment was enacted with the one pervading purpose of securing equal citizenship for the freed slaves. Also true is the fact that this court has time and again denied Americans that promise. But consensus about the 14th Amendment's central motivation does not justify Justice Thomas's myopic treatment of it. The amendment caused a paradigm shift in the trajectory of our nation. The teacher who scolds a student for bullying a classmate hopes the student learns the broader lesson of treating everyone with kindness, not just that one kid. In the aftermath of the Civil War, those who championed the 14th Amendment, both within and beyond Congress, understood the assignment. Their work product used language that transcended race and region. and thereby changed and broadened the meaning of freedom for all Americans. Instead of the limited salve Instead of the limited salve the principal dissent makes it out to be, the Citizenship Clause reflects this universalist approach. Consider first the voices of those outside the chambers of the Senate and the House of Representatives, whose advocacy and organizing culminated in the 14th Amendment. First in the North, as states abolished slavery, and then in the South, after emancipation and the Union's victory in the Civil War, black people who were generally not permitted at the polls or in the halls of power, mobilized nevertheless to advance the universalist vision of belonging and citizenship that eventually won the day. The odds were long and the stakes were high. Indeed, around the time they gained their freedom, former slaves faced a crisis similar in relevant respects to the American immigrant experience, with little in terms of possessions and even less in terms of opportunities to make a living for themselves and their families. Freed blacks were not ushered warmly into the broader community, which, with apologies or compensation, set up for success, or even given the rights and privileges others enjoyed. Though they'd tilled the soil for centuries and had labored to build every building, once freed, they were basically treated as strangers in a not so strange land. This was not for lack of trying to survive and belong on the freedmen's part. They constructed churches, schools, and mutual aid societies, safe zones amidst America's racialized social and economic order. Outside those enclaves, however, freed blacks were characterized as unassimilable, and incapable of full civic participation. Their humanity was disregarded. Serious doubts about their claims to citizenship were also being sown. The reason was clear. An integrated race-blind society under the rubric of all men are created equal required a societal commitment to anti-subordination principles and practices, i.e., a well-resourced effort to undo the damage done to black people by slavery. But even the most ardent opponents of slavery recoiled from that prospect. One solution that gained traction in the early 1800s was to physically separate the freedmen and other black people from the general polity. Anti-slavery Northerners and pro-slavery Southerners found common cause in the idea that freed blacks would surely be happiest in a black-led republic, beyond the contempt of and any competition, beyond the contempt of and competition with white Americans. This vision of paternal caste prompted the creation of the American Colonization Society, which established the colony of Liberia and pushed for freed blacks to relocate there voluntarily. Once freed blacks were out of sight, they would thankfully be out of mind, eliminating any need for a racial reckoning in America. Meanwhile, many states pushed the envelope, passing black laws in the pre-war North and black codes in the post-war South, intending to make it difficult for freed blacks to live and work there. Violence, too, played a significant role in the isolation effort. Those who opposed abolition banded together with those who resented the extra competition in the job market to form marauding mobs. Ransacking black neighborhoods, homes, and stores. And local law enforcement, they did little to help. Before emancipation, per the Federal Fugitive Slave Act, state officers pursued and arrested blacks suspected of having escaped slavery. Afterwards, the cavalry looked the other way when black neighborhoods were terrorized by vigilante violence. The Ku Klux Klan would form and then flourish starting in 1866. Still, most freed blacks resisted the pressure to self-deport. Instead, many started organizing toward the creation of the kind of nation the colonizationists opposed, one that guaranteed liberty and justice for all. In the decades leading up to the ratification of the 14th Amendment, black Americans organized and gathered at more than 600 local and national conventions across the country. There, delegates erected the political and intellectual scaffolding for the 14th Amendment and later for the black civil rights movement more generally. Critically, for present purposes, these visionaries already understood themselves to be American citizens. The refrains, "We are Americans" and "We are citizens," echoed in conference throughout the North. Moreover, birthright figured importantly as delegates frequently characterized their status as that of native-born citizens. The delegates argued that, as such, they had the requisite allegiance, so, at a minimum, the federal government owed them the duty of protection. The famed orator Frederick Douglass was one of these delegates. Capturing the spirit of the moment, Douglass proclaimed that Chief Justice Taney, the author of the majority opinion in Dred Scott v. Sanford, could do many things, but he could not change the essential nature of things. In the absence of the artificial evils of slavery and racial subordination, Douglass explained, the glorious birthright of our common humanity will become the inheritance of all the inhabitants of this highly favored country. Do note this. The citizenship thesis of the colored conventions was thus not the same was not that some new status should be created and conferred on freed blacks. It was instead that freed blacks already had a rightful claim to citizenship because they had been born on American soil. After all, the nation, from its founding, had boldly proclaimed that all men are born free and equal, and that consequently life, liberty, and the pursuit of happiness are inherent in every individual, vested inalienably by natural birthright. No ideal was more inherently American. Now, resting their cause on the Republican standard of the Revolutionary Fathers, freed blacks were knocking at the doors of the Constitution and demanding an entrance. And if asked what evidence they bring to sustain their qualifications for citizenship, they would offer them certificates of birth and nativity. Would the nation live up to its promise? Such universalist appeals were a conscious choice. Yes, black Americans had suffered a singular wrong, and yes, they had fought and bled for the Union, paying a steep price for their freedom. But the delegates did not rest on these laurels. Rather, they drew upon the moral and political force of the universal principles that were already core to the nation's identity. That bears repeating. Freed blacks did not advocate for a unique set of rules that catered only to their situation, nor did they seek to advance their own position relative to or at the expense and exclusion of other marginalized groups. Instead, those whose gatherings helped galvanize the push for full equality understood that a diverse origin does not disprove a common nature, nor does it disprove a united destiny. The firmest foundation for freedom would require an anti-caste reset, for both for his sake and for ours, and would benefit all. During his U.S. Senate candidacy, Abraham Lincoln developed a similar vision. In the lead up to the now famous Lincoln-Douglas debates, Lincoln explained that the promise of liberty and equality in the Declaration of Independence was held sacred by all and thought to include all. Lincoln expressly and intentionally linked the fate of black Americans and immigrant groups, among us perhaps half our people who are not descendants at all of the founders, and noted that the nation's future hinged on a universal definition of citizenship that excluded neither. He explained that the Declaration's promise that all men are created equal was the electric cord that links the hearts of patriotic and liberty-loving men together, regardless of race or descent. The case was made. First there was war, and then the delegates and Lincoln's universalist view of citizenship made its mark on the Constitution. The Civil Rights Act of 1866, the predecessor to the Citizenship Clause, was initially drafted as a spot treatment. Senator Lyman Trumble's first proposal homed in on the freedmen and provided merely that all persons of African descent born in the United States are hereby declared to be citizens of the United States. If that language had prevailed, the view of Justice Thomas asserts today might be well founded. See Thomas's post of finding birthright citizenship's feudal origins inconsistent with Congress's focus on securing equal rights for the freed blacks. But Senator Trumbull changed his mind. The day after he submitted that first proposal, he requested to withdraw the original and offer another in lieu of it to the same purport. Changing the phraseology. Consistent with the views espoused by activists, Trumbull's new proposal adopted a distinctly universalist register. All persons born in the United States and not subject to any foreign power are hereby declared to be citizens of the United States without any distinction of color. This is the language Congress would eventually enact as part of the Civil Rights Act of 1866. And the Civil Rights Act of 1866 would go on to become the basis for the 14th Amendment's Citizenship Clause. Senator Trumbull's progression from specific to universal was more than mere word choice. In the face of the virulent anti-immigrant, and in particular the anti-Chinese and the anti-Romani sentiment of that era, language targeting just freed former slaves would have been the path of least or less resistance. But Senator Trumbull, along with those colleagues who took up the same mantle during the ratification debates, expressly rejected that narrow framing. Do not miss this context. Throughout the mid 19th century, Chinese immigrants to America were often portrayed as coolies, a racist slur implying indentured servitude and allegiance to a Chinese master. Some members of Congress brought that sentiment to the Civil Rights Act's citizenship related debates, notably focusing his attention beyond freed former slaves. Senator Edgar Cowan, for example, argued that German immigrants' children born in Pennsylvania should be citizens, but Chinese immigrants' children should not, because Germans and Chinese were different. In response, Senator Trumbull emphasized that the law he had drafted drew no such distinctions. Undeterred, Senator Cowan would warn again, this time during debates on the 14th Amendment, that the Citizenship Clause would let Chinese immigrants overrun California and double or treble the population of that state. Senator John Conness of California, where anti Chinese sentiment was arguably most pronounced, responded that the children begotten of Chinese parents in California shall be citizens. In fact, he said, the Civil Rights Act had already declared that the children of all parentage whatever should be regarded and treated as citizens of the United States. No senator rose to agree with Senator Cowan or dispute what Senator Conness had said. And no senator said what the principal dissent says today, that the text at issue conferred citizenship only on freed blacks and those in analogous situations. The debates went similarly with respect to the Roma people, who were referred to at the time as gypsies. When asked whether native-born Romani children would be birthright citizens of the United States under the proposed Civil Rights Act, Senator Trumbull replied, "Undoubtedly, President Andrew Johnson apparently agreed." In his message vetoing the act, Johnson noted with disapproval that under the law, the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as the entire race designated as blacks would be birthright citizens, without making any changes to the bill or responding that Johnson was mistaken in his understanding of it or otherwise capitulating to Johnson's views in any respect. Congress overruled that presidential veto. During the ratification debates, Senator Cowan took aim at the Roma people too, characterizing them as undeserving of birthright citizenship because they wandered in gangs, infested society, and imposed upon the simple and weak everywhere. And again, Senator Conness dismissed Senator Cowan's prejudices. The only invasion of Pennsylvania within my recollection was an invasion very much worse and more disastrous to the state, and more to be feared and more feared than that of gypsies. It was an invasion of rebels at Gettysburg. When ratified, the Citizenship Clause thus vindicated the Universalist vision of the delegates at the colored conventions and their allies in Congress. Far from the principal dissent's representations, freed blacks did not receive citizenship as a reward for their military service or for having, through no choice of their own, no other homeland and no allegiance to any foreign power. Instead, the amendment recognized their rightful claim to birthright citizenship simply and solely by virtue of their having been born on American soil. John Bingham, one of the amendment's principal architects, said this clearly. The rights of citizenship are universal because they are the sacred rights of personhood. With this recognition, the U.S. Constitution finally got an anti-caste engine, and with it, the nation gained a new font of legitimacy and vitality. Fast forward 150 years to 2026. Section 1 of the 14th Amendment still contains the same universalist language consistent with its origins and the ratifier's intent. So, respondents say, our Constitution confers citizenship upon almost anyone and everyone who is born on American soil, to include the children of immigrants and temporary sojourners not domiciled in the United States, just as it did at the time of the 14th Amendment's ratification. But the government's view, which the principal dissent adopts, rejects this. Its argument focuses on the fact that the Citizenship Clause had a particular purpose, to reverse Dred Scott's holding that black Americans were not entitled to citizenship. The reasoning is, in essence, that the 14th Amendment recognized freed blacks as citizens because they had fought and bled in the Civil War, had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. Thus, the argument goes, the amendment's guarantees are for only black Americans and those who fit their fought and bled for a country. Those who fit their fought and bled for a country. No other homeland, domiciled mold. That contention is ahistorical for the reasons laid out in Part 1, and those and those explained in the court's opinion. In my view, it is also difficult to square with the notion of a colorblind constitution, which has loomed large in the court's 14th Amendment jurisprudence. The court's conception of a colorblind constitution and the government's and principal dissent's cramped, group specific reading of the Citizenship Clause are two sides of the same coin, stemming from a basic misunderstanding of the relevant history. As I have shown in this opinion, the 14th Amendment is not colorblind. Rather, its core principle is that our nation does not tolerate racial caste, i.e., the systematic subordination that many, even some who opposed slavery, had wished to perpetuate after the Civil War. So the architects of the Second Founding did not think or pretend that race didn't matter. Quite to the contrary. They understood that race made an enormous difference to the lived experiences of all concerned, and to the fate of our Union. Indeed, it is for that very reason that a radical restructuring was required. The Citizenship Clause applies universally precisely because such universal application was necessary to achieve the amendment's own race-conscious remedial purposes. Putting a finer point on this, when colonizationists objected to changing their norms to accommodate the equal citizenship and rights of freedmen, freed blacks and their allies organized to push for a constitution that would bring their own anti-subordination vision to fruition. That kind of ambitious transformation, nothing less than the remaking of the soul of a nation beset by rank, entrenched race-based prejudice, and inequity, did not come for free, or purely by the say-so of those who claimed to be colorblind. It required heavy lifting, a fundamental shift, the very thing for which the 14th Amendment stands, a repudiation of the notion that there is a superior, dominant ruling class of citizens. Citing Plessy and Justice Harlan dissenting, and a willingness to see and strive to eliminate all remaining vestiges of historical subjugation. So the principal dissent is wrong to complain that the court has repurposed the 14th Amendment to protect rights that the Reconstruction Congress never contemplated. Delegates to the colored conventions drew upon their own experiences to successfully argue for a new constitution, one that protected fundamental human rights, including an individual's right to own his body and mind, and the right of personal security and protection against injuries to our bodies or good name. Thus, even in cases where the protagonist was not a black American, this court's 14th Amendment cases have focused, at bottom, on the same universal liberty and equality interests that motivated the 14th Amendment itself. The question is, and always has been, does the affected individual or group enjoy equal dignity? And the correct answer is, and has always been, to heed the 14th Amendment's universalist anti-subordination command. Our nation did not undergo something as profound and world-shifting as Reconstruction for naught. As for after the Civil War, Frederick Douglass frequently reflected on the events of the time through the lens of biblical stories. In one speech, Douglass described how God leveled Sodom and Gomorrah on account of sin, and how, in the aftermath, Abraham stood atop a nearby mountain to survey what remained. The orator used the image of Abraham looking down upon the destroyed landscape to demand that Americans look down upon their own recent self-destruction and all but justified survival. And remember, Douglass declared that his own aim was to show that nations should have memories. Let me back up. After the Civil War, Frederick Douglass frequently reflected on the events of the time through the lens of biblical stories. In one speech, Douglass described how God leveled Sodom and Gomorrah on account of sin, and how, in the aftermath, Abraham stood atop a nearby mountain to survey what remained. The orator used the image of Abraham looking down upon the destroyed landscape to demand that Americans look down upon their own recent self-destruction and all but unjustified survival. And remember, Douglass declared that his own aim was to show that nations should have memories. In the time since Douglass's prescient observation, Americans have come to learn that fading memories are not the only danger. The distortion of historical facts, retellings that reimagine and repurpose past events to lend credence to misbegotten aims, may be an even greater threat. Yet here we are. The government, the principal dissent, and a handful of revisionist commentators now vigorously promote an interpretation of the Citizenship Clause that diverges sharply not only from what the text says, but also from the historical record as interpreted by the keepers of the Call of Remembrance, trained historians. What is more, This alternative account pitches black Americans against immigrants when the advocates who promoted the 14th Amendment did no such thing. Freed blacks fought for the shared humanity of all people, and the great emancipator eventually foresaw that the only path forward that could prevent a return, in any form, to slavery and race based subordination was to link the fates of all. Ultimately, then, it is the government and Justice Thomas who have repurposed the 14th Amendment by ignoring that our Constitution stands firmly against caste and subjugation on all axes and in all manners, then deny the clear universalist vision shared and proclaimed by the 14th Amendment's framers, to rebuild a shattered empire, to plant deep and solid the cornerstone of eternal justice, and to erect thereon a superstructure of perfect equality of every human being before the law. Of course, the ultimate irony is that for all the talk about the detestable Dred Scott decision, the government and the principal dissent propose a return to its core tenet. Their bottom line is that, for certain people, being born on American soil will not suffice to confer citizenship. It is that odious conclusion that the Citizenship Clause plainly rejects, as the court explains. I add only that the 14th Amendment's universalist aims should forever be the death knell for this kind of claim, one that seeks to make bloodline the marker of birthright. The America that was reborn from the rubble of the Civil War simply does not countenance that inequitable result. Thankfully, a majority of the court remembered this today, and has dutifully preserved the most basic animating principle of our nation's founding, that all human beings are created equal once more. Justice Kavanaugh concurring in the judgment and dissenting in part. Executive Order number 14160 established new exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country. The court today holds that the order violates the 14th Amendment to the Constitution. I respectfully disagree with the court's constitutional holding. In my view, the executive order does not violate the 14th Amendment, but the order does contravene a federal statute, 8 U.S.C. subsection 1401A. Congress could, consistent with the 14th Amendment, amend subsection 1401A or otherwise enact new legislation establishing exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country. But Congress has not yet done so. I first consider plaintiff's statutory argument. The statutory analysis is straightforward, and the court could have, in my respectful view should have, decided the case on that narrow ground. Initially enacted in 1940, subsection 1401A of Title 8 provides that persons born in the United States and subject to the jurisdiction thereof shall be nationals and citizens of the United States at birth. That statutory language mirrors the text of subsection 1 of the 14th Amendment, which was ratified in 1868, and similarly provides all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. This court's 1898 Wong Kim Ark decision interpreted the subject to the jurisdiction language of the 14th Amendment. That decision adopted a general rule of birthright citizenship for those born in the United States, with 4 disparate exceptions for children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation of part of our territory, and children of members of the Indian tribes. Importantly, the Wong Kim Ark decision treated those 4 exceptions as a closed set for constitutional purposes, meaning that Congress could not create other exceptions to birthright citizenship, although Congress could eliminate one or more of those 4 exceptions. In 1940 and 1952, Congress employed the exact language from the 14th Amendment, subject to the jurisdiction thereof, in comprehensive new immigration and naturalization laws that provided for birthright citizenship. The relevant provisions are now codified in 8 U.S.C. subsection 1401A. Because subsection 1401A uses the same language as the 14th Amendment, the statute has long been interpreted to adopt Wong Kim Ark's general rule of birthright citizenship, subject to the exceptions identified in that case. If Congress in 1940 or 1952 wanted to create new exceptions and thereby test Wong Kim Ark's statement treating the 4 exceptions as a closed set, Congress presumably would not have repeated the precise language that this court had interpreted in Wong Kim Ark to contain only those 4 exceptions. Stated more doctrinally, Congress must be considered to have adopted also the construction given by this court to such language and made it a part of the enactment. Importantly, moreover, from the time of those statutory enactments in 1940 and 1952 all the way through 2025, the executive branch consistently interpreted subsection 1401A to encompass only those Wong Kim Ark exceptions to birthright citizenship. The government here does not contest that historical point. That long and consistent executive branch interpretation further indicates that subsection 1401A incorporates only those exceptions. See Loper Bright Enterprises versus Raimondo. Interpretations issued contemporaneously with the statute at issue and which have remained consistent over time may be especially useful in determining the statute's meaning. In 2025, however, Executive Order number 14160 sought to add two new exceptions to birthright citizenship for children born to foreign citizens who are either illegally or temporarily in the United States. In doing so, the executive order goes beyond what subsection 1401 authorizes. For the executive order to be lawful, therefore, Congress would need to amend subsection 1401A or otherwise enact new legislation to encompass those two new exceptions. As of now, Congress has not done so. Over the last 30 years, Congress has considered numerous proposed bills to alter birthright citizenship, but Congress has never actually passed such legislation. Unless and until Congress enacts such legislation, the executive order contravenes the federal statute. I next address the 14th Amendment issue. As revealed by the court's opinion with its detailed account of history and precedent, and by the weighty and thoughtful dissents, the constitutional issue is far more complicated than the statutory issue. After reading those scholarly opinions, one thing seems evident. The constitutional issue is not straightforward, much as we might want it to be. That is another reason why, in my respectful view, the court should have decided the case on the narrow and straightforward statutory ground. In any event, because the court addresses the Constitution and because I respectfully disagree with its analysis of that highly consequential issue, I too will briefly address it. Ratified in 1868, the Citizenship Clause of subsection 1 of the 14th Amendment provides, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. In 1898, as noted above, Wong Kim Ark interpreted the 14th Amendment's subject to the jurisdiction language to provide a general right of birthright citizenship, with four disparate exceptions for children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation of part of our territory, and children of members of the Indian tribes. Importantly, Wong Kim Ark indicated that the four exceptions were a closed set, meaning that there can be no additional exceptions recognized based on subsequent circumstances or developments. And the decision has consistently been read that way, including by plaintiffs and the court today. But Wong Kim Ark's treatment of the exceptions as a closed set is incorrect, in my view. Considering the four exceptions as a permanently frozen or closed set as of the 14th Amendment's ratification in 1868, such that there can be no subsequent exceptions recognized based on new developments after 1868, is inconsistent with the court's longstanding approach to constitutional interpretation in a variety of areas. To spell that out, the Constitution is an enduring document, and its principles were designed to, and do, apply to modern conditions and developments. The original constitutional principles do not change absent a constitutional amendment, but the relevant principles, both the rules and exceptions alike, must be faithfully applied not only to circumstances as they existed in 1787, 1791, and 1868, for example, but also to modern situations that were unknown or unanticipated by the Constitution's framers. Stated otherwise, the meaning of rules is constant, only their application to new situations presents a novelty. See Justice Scalia reading law, and then also see Heller versus District of Columbia, Kavanaugh dissenting, and Scalia in a matter of interpretation. Courts apply original meaning to new and unforeseen phenomena. And then also the transcript of oral argument discussing those interpretive principles. In Fourth Amendment cases, for example, courts apply the reasonableness requirement to searches of cars even though cars did not exist in 1791 or 1868. See, for example, Carroll v. United States. In First Amendment cases, courts apply free speech protections to the Internet, notwithstanding that the Internet did not exist in 1791 or 1868. See Moody v. NetChoice LLC. In Second Amendment cases, this court applies the amendment to semi-automatic handguns, even though those did not exist in 1791 or 1868. citing District of Columbia v. Heller. From the other direction, moreover, this court recognizes constitutional exceptions based on new circumstances when the new exception is relevantly similar to those exceptions that existed in 1791 or 1868. This court's constitutional precedents do not treat the 1791 or 1868 exceptions as a closed set trapped in amber, citing United States v. Rahimi. So ordinarily, both the relevant constitutional rule and the constitutional exceptions, as of 1787, 1791, or 1868, as the case may be, apply to new circumstances. As the court has said before, discerning and developing the law in this way is a commonplace task for any lawyer or judge. Indeed, at oral argument in this case, many members of the court explored that critical interpretive point at some length with counsel. The Citizenship Clause of subsection 1 of the 14th Amendment should be no different. The court's 1898 decision in Wong Kim Ark recognized 4 exceptions that existed as of the 14th Amendment's ratification in 1868. Therefore, under basic tenets of constitutional interpretation, other exceptions can be recognized when the new exceptions, 1, are based on subsequent developments or circumstances that are new, i.e., largely unknown or unanticipated by the framers of the 14th Amendment, and 2, are relevantly similar to the 4 previously recognized Wong Kim Ark exceptions. Here, that interpretive principle would support additional exceptions for children born to foreign citizens unlawfully or temporarily in the country. First, significant illegal immigration into the United States is a new circumstance that was largely unknown as of 1868, and that the framers of the 14th Amendment could not have fully anticipated. And the framers likely would not have anticipated, and presumably would not have intended, the odd result of granting a substantial birthright citizenship benefit to 1, those foreign citizens who violate U.S. immigration law and illegally enter or overstay and then have children in the United States, or over 2, or have children in the United States over, and 2, those foreign citizens who follow U.S. immigration law and have children in their home countries while seeking to lawfully immigrate to the United States. Nor presumably would they have wanted to grant constitutional birthright citizenship to children of foreign citizens unlawfully in the country while simultaneously denying constitutional birthright citizenship to children of tribal American Indians. So too, the issue of temporary visitors who give birth in the United States presents a new and different circumstance than in 1868 given the significant changes in immigration laws and travel. And second, those 2 categories of foreign citizens, namely those unlawfully or temporarily in the country, are relevantly similar to the 4 categories of persons recognized as exceptions in Wong Kim Ark. The only apparent principle unifying the 4 disparate exceptions listed by the court in Wong Kim Ark, especially in light of the exception for tribal American Indians, is that the parents in all of those varied circumstances were not U.S. citizens and were citizens of other nations, whether tribal or foreign. An exception for those born in the United States to foreign parents unlawfully or temporarily in the country is consistent with that principle and therefore with the 14th Amendment. All of that said, as noted above, Congress in 1940 and 1952 enacted a statute, subsection 1401A, that at the time and since has always been understood to authorize only the 4 Wong Kim Ark exceptions. If Congress amends subsection 1401A or otherwise enacts a statute creating the new exceptions along the lines of the executive order for children born to foreign citizens unlawfully or temporarily in the country, such a statute, as I see it, would pass constitutional muster. For those reasons, to reiterate, the executive order does not violate the 14th Amendment, but the order does contravene 8 U.S.C. subsection 1401A. Consistent with the 14th Amendment, Congress could amend subsection 1401A or otherwise enact new legislation establishing exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country, but Congress has not yet done so. Justice Thomas, with whom Justice Gorsuch joins dissenting. This court's decision in Dred Scott v. Sanford would have permanently denied citizenship to blacks as a subordinate and inferior class. After the Civil War, the Reconstruction Congress overruled Dred Scott, first with the Civil Rights Act of 1866, then with the Citizenship Clause of the 14th Amendment. Both the Civil Rights Act and the Citizenship Clause guaranteed citizenship to persons born and domiciled in the United States regardless of their race. Neither guaranteed citizenship to persons who were not domiciled in the United States. Blacks were entitled to citizenship because they were Americans. They had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. They fought and bled in the same battles, gained and gloried in the same victories, and were liable to be called upon to defend America in time of war, alongside every other citizen. The Citizenship Clause thus guaranteed them the dignity and glory of American citizenship, so as to ensure that they would never be treated as second class under the law. The same could not be said for the children of foreign temporary visitors. Foreign temporary visitors were attached to their home country, lacked similar bonds to this country, and would not be called upon in time of war. Americans, consistent with their settler ethos, believed that citizens were the people who called a place home. Accordingly, domicile, a person's legal home, played a key role in both state and national citizenship in America. A person was a citizen of the state where he had his domicile, citing Barber v. Barber. When foreigners temporarily visited, their national character was unchanged. Such visitors were strangers, not subjects. A person born here but domiciled in a foreign land was therefore considered as much a stranger to the country as his father. That is why, when Dred Scott went to court, he argued that to be a citizen, it is only necessary that he should have acquired a domicile. After this court held that Scott was not a citizen because he was black, Republicans in Congress, such as Representative John Bingham, stated that a person was a citizen if he was born and domiciled in the United States. Scott was a citizen, in their view, because he was born to Americans, not to temporary sojourners. As Frederick Douglass had put it, the freedmen sought citizenship not as aliens nor as exiles, but as Americans. Congress implemented the principle that citizenship follows birth and domicile in the Civil Rights Act of 1866 and then in the Citizenship Clause of the 14th Amendment. The Civil Rights Act guaranteed citizenship to persons who were both born in the United States and, as relevant here, not subject to any foreign power. The phrase "not subject to any foreign power" excluded from citizenship children of foreign temporary visitors who were subject to the power of their home nation. The Citizenship Clause, which the same Congress passed shortly after the Civil Rights Act, was understood to have the same meaning. It guaranteed citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. A person was subject to the jurisdiction of the government of his domicile. Domicile was the foundation of jurisdiction over persons. The government of a person's domicile had broad power over that person, including with respect to his personal affairs, his conduct abroad, his personal taxes, and the mutual duties of protection and allegiance. So, as the senator who introduced the Citizenship Clause explained, the word jurisdiction, as here employed, ought to be construed so as to imply a full and complete jurisdiction, the same jurisdiction in extent and quality as applies to every citizen of the United States now. See the 39th Congress First Session Statement of Senator Howard. After all, Congress would have no right to make citizens of persons temporarily resident. The Statement of Senator Trumbull. The Citizenship Clause was consistently interpreted not to apply to the children of foreign temporary visitors, who were by definition not domiciled in the United States. Regardless of administration or party, the federal government for decades after ratification regularly denied claims to citizenship by children who were born in the United States but not domiciled here. When a child was born in the United States to parents domiciled abroad, he was not therefore under the statute and the Constitution a citizen of the United States by birth. See the letter from Secretary of State Bayard to Winchester. Scholars agreed. A child born within the territory of the United States of alien parents was not a citizen unless his parents were permanently domiciled within the United States. This court agreed. The Citizenship Clause excluded from its operation children of citizens or subjects of foreign states born within the United States, and Congress agreed. The Citizenship Clause did not extend to a child born here, but subject to any foreign power. As Justice Harlan would write in his dissent in Plessy v. Ferguson, the Citizenship Clause gave citizenship to all born or naturalized in the United States and residing here. The court offers a different account. American citizenship, the court says, was based on a medieval English feudal principle, according to which each person owed personal service to the lord of the soil as his master, a perpetual servitude that was born with the child and only ended in the grave. Americans, the court says, adopted this feudal principle as a rule of American citizenship with little fanfare. Then, according to the court, the Reconstruction Congress codified that feudal principle with the words not subject to any foreign power in the Civil Rights Act and subject to the jurisdiction thereof in the Citizenship Clause. Then the court says the clause's meaning was definitively settled by dicta in United States v. Wong Kim Ark. With due respect, the court's account is not historically accurate. The court says that the Citizenship Clause incorporated the English feudal principle that subjects owed lifetime servitude to the king who owned the soil on which they were born, but Americans, unsurprisingly, rejected this feudal principle. The court's theory of American citizenship is based on the opinion of a New York assistant vice chancellor in an inheritance dispute called Lynch v. Clark. But the assistant vice chancellor's reasoning, whatever it was worth, was not even followed in New York by the time of the Citizenship Clause. Finally, the court reasons that dicta in Wong Kim Ark settled the meaning of the clause. But Wong Kim Ark itself emphasized that its holding was limited to persons domiciled in the United States, and scholars and government officials continued to agree after Wong Kim Ark that the Citizenship Clause did not extend to the children of foreign temporary visitors. The rule remained what it always was. A child born on American soil of a stranger or a traveler passing through the country or temporarily residing here was not a citizen. The court today takes the extraordinary step of holding facially unconstitutional the president's order excluding from citizenship the children of foreign temporary visitors and illegal aliens. In doing so, the court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights to the freed blacks, but has instead been repurposed for political projects that the Reconstruction Congress did not support. Because many potential applications of the president's order are consistent with the original public meaning of the Citizenship Clause, I respectfully dissent. I begin with early American practice related to citizenship and nationality, which informed what the Citizenship Clause means. In America, you were generally a citizen if you were born here and this was your home. The legal word for home was domicile. The concepts were so linked as to be taken as effectively synonymous at times, such that Justice Bushrod Washington could say, citizenship means domicile, home, permanent residence. The same correspondence has persisted throughout American history. See, for example, Harding v. Standard Oil Company. Domicile and citizenship are substantially synonymous terms in most cases. Citizens were not the people who were temporarily passing through a territory or who happened to be born within it. Citizens were the permanent members of the body politic, the people whose roots were in a place, who called that place home, and who would, if necessary, go to war for that place. The law of both state and national citizenship reflected this principle. Domicile was critical for state citizenship. As Chief Justice Marshall explained, a person was a citizen of that state in which he has a fixed and permanent domicile. Citing Brown v. Keene, and for example, Eberly v. Moore, citizens if domiciled, Barber, citizenship by domicile, and then Joseph Story's commentaries on the Constitution, change of citizenship by change of domicile. Temporary visitors, it followed, were not citizens. When a person went to a new state on a mere temporary visit for a transient purpose, Justice Story explained, he could not thereby claim to be a citizen of such state. Instead, to become a citizen of the state to which he removes, someone had to show that he had his domicile there. The same rule remains in place today. As a general matter, an individual is deemed a citizen of the state of his domicile. Domicile was also critical for national citizenship. As this court stated the rule, when a person acquires a domicile in a nation, he becomes a member of the new society, at least as a permanent inhabitant. Domicile played a role in determining someone's national character, which would change whenever he removes to a foreign country and settles himself there, with an intention permanently to reside there. He was a subject of the nation where he was domiciled. He followed the character of that country, in war as well as in peace. Thus, the view of the executive branch was that when a person acquired an American domicile, the law enjoins upon other nations to respect him in regard to protection as an American citizen. See here the Congressional 40th Congress, second session, report of 1868. Domicile confers a national character. It does not allow anyone who has a domicile to decline the national character thus conferred. His status remains as long as the domicile is retained and is changed with it. This approach was consistent with this country's settler ethos. Daniel Webster, who wrote that no government has carried the general presumption further than the United States that a person attains a new national character when he settles and intends permanently to reside in a nation. Although some nations would lay claim to anyone born in their land or any descendant of their citizens, America viewed its people as the people who built their lives here. A person domiciled here pays the same price for his protection as native born or naturalized citizens pay for theirs. In war, he shares equally with them in the calamities which may befall the country. His services may be required for its defense, and his life may be periled and sacrificed in maintaining its rights and vindicating its honor. See, for example, the Dos Hermanos, reasoning that if upon his return to New Orleans he acquired a domicile there, he became a reintegrated American citizen. And the Mary and Susan, discussing the effect of domicile upon national character. The United States thus did not claim as a citizen every child born on its soil. Instead, pursuant to the principle that children followed their parents' domicile, a children was a citizen of the place where his parents were domiciled. A child born of foreign parents is not, on principles of natural reason, necessarily to be considered as a citizen of the country where he is born. If he was born in the country, but both his parents were strangers, not designing a permanent change of country, when he was as much a stranger to the country as his father, the rule was that when a subject is traveling or sojourning abroad, he continues under the protection of his home nation. So his children are an exception to the rule, which makes the place of birth the test of citizenship. See also the 37th Annals of Congress by the statement of Representative Hempel. For citizenship to be acquired by birth, a child must be born to parents belonging to no other nation or tribe. And then see Hardy v. de Leon. A child born on American soil to parents domiciled in the then Republic of Texas was a citizen of Texas. And then the Political Code of New York, subsection 5, citizenship requires domicile and excludes children of transient aliens. The relationship between citizenship and domicile was a matter of general law, from which the political branches could depart by statute, but those statutes also typically tracked the domicile rule, so Congress retained the prerogative to set the terms for becoming a naturalized citizen and could impose requirements beyond domicile. But when Congress enacted naturalization statutes, they too generally tracked the domicile requirement. Let's see, for example, Act of March 26, 1790, requiring 2 years of residence for naturalization. Act of January 29th, 1795, requiring 5 years of residence for naturalization. And even when a person was domiciled here and not formally naturalized, he was already considered a citizen for some purposes. Before being naturalized, domiciliaries were de facto, though not de jure, citizens of the country of their domicile, or domiciled citizens. Likewise, for other purposes, national citizenship was not an independent concept, but simply derivative of the state citizenship. Every citizen of a state, it was often said, was ipso facto a citizen of the United States. In these contexts, too, national citizenship required domicile because state citizenship required domicile. Of course, birthplace closely correlated with domicile. Most children were born where their parents were domiciled and where, as a result, they were domiciled. The correlation was especially strong in the early 19th century, when crossing an ocean for a temporary visit was an unappealing prospect for pregnant women. Because birthplace was often a heuristic for domicile, it could be generally stated that children were citizens of their place of birth. But when the specific question arose, a reasonable qualification to that general statement accepted children of parents who were in interior in the country or abiding there for temporary purposes. And we'll stop there for now, and I'll continue in the next few days. But as always, if there's any case you'd like me to read, just drop in the comments and maybe take a look. Thank you.